I have carefully reviewed last Friday's judgment by the majority of the Appeals Chamber judges of the International Criminal Court, acquitting Mr. Jean-Pierre Bemba Gombo of the charges of war crimes and crimes against humanity. It is clear that serious crimes were committed in the Central African Republic by Mr. Bemba's forces, which resulted in great suffering in the Central African Republic. My office has been in touch with the legal representatives of the victims in the case, and we join them in their disappointment over this decision and its impact on the victims. As prosecutor and an officer of the court, I must and will respect and accept the decision and its finality. I must uphold the integrity of the court's processes. However, certain features of the majority judge's ruling cause me concern. As noted by the two dissenting judges in their extensive joint opinion, the majority of the Appeals Chamber departed from the traditional model of appellate review of factual errors which had been consistently applied not only by the ICC Appeals Chamber since its inception, but also by the appellate chambers of the United Nations ad hoc tribunals and other international criminal jurisdictions. It is unfortunate that this significant and unexplained departure from the court's previous jurisprudence, as the dissenting judges described it, and its replacement by new, uncertain, and untested standards has taken place in the most serious case of sexual and gender-based violence decided upon by this court to date. Ever more so now, when there is an acute need to send a clear signal globally that such abhorrent crimes must not go unpunished. The majority judges also seem to have departed from previous court rulings, as well as international practice concerning the manner in which the prosecution sought to charge cases involving mass criminality. The level of detail that the prosecution may now be required to include in the charges may make it difficult to prosecute future cases entailing extensive campaigns of victimization, especially where the accused is not a direct perpetrator, but a commander remote from the scene of the alleged crimes, but who may bear responsibility for them as the superior, having effective control over the perpetrators. In the court's legal framework, the Appeals Chamber's decisions are final. There is no further possibility to appeal its judgments. That is why, in my view, it is so critically important that the appeals judges maintain the cautious approach to appellate review that it has always previously adopted. I hope that there will be, in future, a return to those standards of appellate review. I still believe that the case against Mr. Bemba was a strong and well-documented one. It was supported by the body of the evidence presented to the court. The charges of war crimes and crimes against humanity brought against Mr. Bemba were confirmed by the judges of ICC's pre-trial chamber. Trial proceedings led to a unanimous conviction. The 5 judges of an appeals chamber were unable to reach unanimity. 2 judges in the majority decided to acquit. 1 judge in the majority allowed the appeal but favored a new trial. The 2 dissenting judges upheld Bemba's conviction. In the end, Mr. Bemba was acquitted because a majority of the appeals chamber judges found Mr. Bemba not to be individually liable for the crimes as a commander. In closing, I would like to come back to the victims. The long journey for justice in the Bemba case is a testament to the unwavering courage and determination of the victims of the Central African Republic to fight against impunity. The Bemba case will always represent an important recognition of the crimes of rape, murder, and pillaging suffered by the victims in the Central African Republic at the hands of le Mouvement de Libération du Congo troops that were effectively under the control and authority of Mr. Bemba, who had knowledge of the crimes during the 2002 to 2003 Central African Republic conflict. The Bemba Appeals judgment confirms this. My office has stood in solidarity with the victims in the Central African Republic for over 10 years. We overcame witness interference, which threatened to derail the case and our pursuit of justice for the victims. Mr. Bemba, along with others, were convicted and held criminally responsible for their attempts to interfere with the administration of justice at the court. Despite the appeals judgment acquitting Mr. Bemba and its effect of halting the reparations proceedings, the Trust Fund for Victims at the ICC may find itself in a position to provide a reparative response on its own account. I take note and welcome today's decision by the Trust Fund for Victims Board of Directors to accelerate the launch of its assistance mandate program in the Central African Republic, which will take into consideration the harms suffered by the victims in the Bemba case, as well as harms suffered from additional sexual and gender-based violence arising out of the situation. The court will continue with renewed determination its fight against impunity for perpetrators of the most serious crimes. And to that end, my office is vigorously committed to doing its part, with the plight of the victims foremost and always on our minds.